A revocable living trust can pass your assets to your family after you die, without any involvement from a Florida probate court. Here's how it works. A revocable living trust is a legal document you create during your lifetime that holds your assets and controls what happens to them when you die, or if you become incapacitated. In Florida, revocable trusts are governed by Chapter 736 of the Florida Statutes, known as the Florida Trust Code. Let's break down the key terms. The person who creates the trust is called the settlor. The person who manages the assets inside the trust is called the trustee. In most cases, when you create a revocable living trust, you are both. You serve as your own settlor and your own trustee, while you are alive and capable. The people who receive the assets are called beneficiaries. Here is the central benefit. When assets are held inside a revocable living trust and you die, those assets do not have to go through Florida probate court. Your successor trustee, the person you name to take over, can transfer the assets directly to your beneficiaries, according to your trust's instructions. No court filing, no waiting for a judge, no public record. The word revocable means you can change this trust at any time while you are alive. You can add assets, remove assets, change beneficiaries, or cancel the trust entirely. Under Florida Statute, Prom 736.0602, a trust is revocable by default unless the document specifically states otherwise. Now here is an important Florida-specific requirement. Under Florida Statute, Prog 736.0403(2)(b), for a revocable trust to be valid in Florida, the document must be signed by you in front of 2 witnesses and a notary public, the same formalities required for a Florida will. This is not the rule in every state, and it is a common mistake people make when using online trust forms designed for other jurisdictions. One more thing to understand. A revocable living trust does not protect your assets from creditors while you are alive. Under Part 736.05051, because you control the trust and can revoke it, your creditors can still reach those assets. Asset protection is a feature of irrevocable trusts, which we cover separately. To make a revocable living trust work, you must fund it, meaning you must actually transfer ownership of your assets into the trust's name. A trust with no assets in it has no effect at death. This is one of the most common and costly mistakes in estate planning. Key Florida-specific detail. Under Florida Statute, POW 736.0403(2)(b), a revocable trust executed by a Florida resident must be signed with the same formalities required for a will, 2 witnesses, and a notary. Online trust templates designed for other states often do not meet this standard, which can render the trust's death distributions invalid under Florida law. A revocable living trust is one of the most flexible tools in a Florida estate plan, but only if it is properly executed and funded from the start.